Thank you, Dean Zeri and Professor Schreiber. I also want to thank the Chancellor Bergenau and the Jefferson Lecture Committee for the invitation to deliver this year's lecture. For me, as a non-academic, it's quite an honor to be before an audience like this. At the same time, I appear before this audience from the UC community with a sense of trepidation. My wife, Keo, and I lived in Berkeley for 10 years. That was at the height of what they called the student revolution from the mid-60s to the mid-70s. If I learned anything from that experience, it's that Berkeley students are not bashful about voicing their honest criticisms on any topic. And I suspect that tradition has not changed. Nonetheless, because my purpose today is to encourage public debate on the topic that I'm about to address, I hope that you too will forthrightly express your views on this important topic. As Professor Schreiber said, my topic is the war on terror and the rule of law. Now, I had to select this topic, I think, weeks and weeks ago before I actually prepared the lecture, so the lecture itself will be somewhat narrower, but still in that general area. At least since the end of World War II, generations of American lawyers and judges have preached the benefits of the rule of law throughout the world. I've been fortunate to be among that legion, having made numerous trips abroad at the behest of the former U.S. Information Agency and the Department of State, as well as a number of non-governmental organizations. And the American message invariably has been received with great favor and an abundance of goodwill, whether addressed to officials of the former Soviet Union, to former communist bloc lawyers and judges in Eastern Europe, or to legal groups in third world countries in Africa, the Middle East, Asia, the Pacific Islands, and elsewhere in the world. The American legal messenger, so to speak, has been regarded throughout the world as a trusted figure of goodwill, primarily because he and she have been closely identified with our message that the rule of law is fundamental to a free, open, and pluralistic society. What is the rule of law message that Americans have been associated with? Quite simply, it is that ours is a government of laws and not of men or of persons, that no one, not even the president, is above the law, that the government is bound by the Constitution and by the laws duly enacted in conformance with the Constitution. But the strength and credibility of that message has been steadily undermined and eroded over the last 6 years since we began the so-called war on terror. The American rule of law message and messenger have been greeted with increasing skepticism and even open hostility. This dramatic shift in world opinion has been caused by the actions that we have taken in the war on terror that have belied our commitment to the rule of law. This has been especially true of our detainee treatment policies in the war on terror. To put it bluntly, since 9/11, the administration has been at war with the rule of law. While declaring that we are at war with al-Qaeda and the Taliban, it has refused to accord prisoner of war status to enemy combatants captured on the battlefields and has declined to afford them the protections of the Geneva Conventions. Although there is no declared war, the administration insists that it can detain suspected terrorists, including those captured in non-combat locations, indefinitely for the duration of the war on terror. The administration has attempted to suspend the writ of habeas corpus in contravention of the Constitution and in direct violation of our obligations under the Convention Against Torture The administration has transferred detainees to regimes it knows will subject them to torture. Indeed, torture for the sake of gathering intelligence is the very purpose of the CIA's extraordinary rendition program. The administration insists that it can hold prisoners in the U.S., including U.S. citizens, indefinitely without charging them with any crime, while denying them access to counsel and a hearing of any kind. Underlying this assault on the rule of law is the notion that the President is not bound by law, that he can ignore the command of the Constitution, treaties, and statutes of the United States when acting as Commander-in-Chief. Yet, when the assumptions underlying the administration's legal position in the war of terror have been challenged in court, the administration's litigation record has been far from successful. So with that introduction and that preliminary observation, I want to focus today on just one aspect on the war on terror, and that is our detainee treatment policy. First, I outline the historical development of that policy, and then I point out why I believe that those detention rules fall far short of the rule of law. And finally, I make some suggestions and express some thoughts on what is needed to bring our detention policy in line with the rule of law and with our Constitution, and will also put us back on the road toward gaining the respect and credibility that the U.S. is a nation of laws and not of men. Since September 11, in 2001, the administration has engaged in a practice of detaining suspected terrorists without criminal charge and without designation as prisoners of war. The greatest number of these detainees, which I'm sure most of you know, are the detainees being held at the Guantanamo Bay Naval Base in Cuba, approximately 375 of them. But there are also detainees being held in the U.S. In the chronological development of the legal framework governing detainee treatment, there are what I consider to be three major phases, and for convenience I call them Phase 1, Phase 2, and Phase 3 as I describe their development. In Phase 1 week after the World Trade Center and Pentagon attacks on September 11 in 2001, Congress passed the Authorization for the Use of Military Force, the AUMF it's called, which authorized the President to, quote, use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attack that occurred on September 11 of 2001, or harbored such organizations or persons. The administration has relied on the AUMF to argue that the all necessary and appropriate force provision includes the power of indefinite detention of suspected terrorists as enemy combatants. On November 11 of 2001, the President signed a military order authorizing the Secretary of Defense to detain any alien who the President determines to be a member of al-Qaeda or had engaged in or aided and abetted or conspired to commit international terrorism or had harbored someone who had done any of those things. The order also authorized the trial of such detainees before military tribunals and denied the detainee the right to seek recourse in any other tribunal, including the U.S. courts. The order specifically mentioned the AUMF as authorizing the detentions and military commissions. To date, only 10 detainees have been charged with violating the laws of war by a military commission under either the military order or under the subsequently enacted Military Commissions Act. And no commission has reached a final verdict in any case. During the fighting in late 2001 in Afghanistan, hundreds of people who were suspected associates of the Taliban government or of al-Qaeda were captured either by U.S. military forces or handed over to U.S. forces by anti-Taliban Afghan allies. They were originally detained in Afghanistan, but by February of 2002, 300 detainees had been transferred to Guantanamo Bay. Rather than treating the suspected Taliban and al-Qaeda fighters as prisoners of war, the administration referred to these detainees as unlawful combatants, who by virtue of that status were ruled by the administration to fall outside the protections of the Third Geneva Convention. The administration justified this decision in part based on the fact that al-Qaeda was not a state party to the Geneva Conventions. The designation of these enemy combatants as unlawful combatants was made exclusively by the executive branch, and detainees were afforded no forum to contest this designation until the combatant status review tribunals were implemented in 2004. Given these circumstances, various detainees began filing petitions for writs of habeas corpus in U.S. federal courts. In the summer of 2004, the Supreme Court ruled on 3 such cases. On June 28 of 2004, in a case called Rasool versus Bush, the Supreme Court addressed the status of alien detainees at Guantanamo Bay. 2 alien Guantanamo detainees had filed federal petitions seeking their release. The district court dismissed the petitions for lack of jurisdiction, relying on a World War II case called Johnson versus Eisentrager. And the Court of Appeals for the District of Columbia affirmed that dismissal, also relying on that same Eisentrager case. When the case got to the Supreme Court, that court reversed. The court held that the federal habeas corpus statute does grant jurisdiction to federal courts to hear extraterritorial habeas petitions by the detainees in Guantanamo. The court distinguished the Eisentrager case from the current detainees. The detainees in Eisentrager had been tried before a military commission and found guilty of violating the laws of war, whereas the Guantanamo detainees had not been afforded any form of hearing or judicial review of their confinement. The court also noted that unlike occupied Germany in the 1940s, the U.S. exercises complete jurisdiction and control over Guantanamo Bay under the lease with Cuba, even though the U.S. is not the ultimate sovereign. Rather than ruling on any larger constitutional question raised by the potentially indefinite confinement of the detainees at Guantanamo, the court in Rasool focused only on the question of how to interpret the federal habeas corpus statute, concluding that Eisentrager did not categorically exclude aliens detained in military custody outside the U.S. from the privilege of litigation in U.S. courts. The Supreme Court permitted the habeas petitions to proceed and remanded the cases to the lower court for consideration of the merits. On the same day as it decided Rasool, the Supreme Court also decided the case called Hamdi versus Rumsfeld, which also involved an enemy combatant detainee. But the petitioner in that case was a U.S. citizen. Hamdi had been captured by the Northern Alliance in Afghanistan and handed over to U.S. forces. Initially, he was detained in Guantanamo until his American citizenship was discovered when he was transferred to a naval brig in the U.S. mainland. He was held incommunicado, without access to counsel, without being charged with any crime. His father filed a habeas petition in federal court on his behalf, after which the government produced a declaration averring that Hamdi was an enemy combatant. The district court found that unpersuasive and ordered further document production by the government. But the Fourth Circuit Court of Appeals reversed the district court, reasoning that because Hamdi had been captured in a combat zone on foreign soil, no further review of the basis of his confinement was due. The Court of Appeals also reasoned that such detention was valid under both the AUMF, the authorization for the use of military force, and the President's inherent authority as Commander-in-Chief. The Fourth Circuit Court of Appeals then ordered that the petition be dismissed. On review by the Supreme Court, that court faced two issues. The first issue was whether the government had the authority to detain within the U.S. a citizen apprehended abroad as an enemy combatant. Hamdi had argued that his detention violated the Non-Detention Act, which bars detention of a U.S. citizen without congressional authorization. There was no majority opinion in that case, but a plurality of the court concluded that the government had the authority to detain a U.S. citizen as an enemy combatant as part of the all necessary and appropriate force clause of the AUMF. Justice Thomas added the fifth vote agreeing that the government was authorized in holding Hamdi as an enemy combatant because of his inherent authority under the Constitution. Justice Scalia, however, dissented, joined by Justice Stevens, and he argued that the government cannot detain a U.S. citizen without charge unless Congress expressly suspends the writ of habeas corpus, as provided in the suspension clause of the Constitution. In another dissent, Justice Souter, joined by Justice Ginsburg, argued that holding a U.S. citizen as an enemy combatant does violate the Non-Detention Act and that the AUMF did not authorize such detentions. The second issue in the case was to what, if any, form of judicial review of his detention was Hamdi entitled. Every justice except Justice Thomas agreed to reverse the Fourth Circuit on this question and hold that Hamdi was entitled to some form of due process. The plurality opinion concluded that due process demands that a citizen held in the U.S. as an enemy combatant be given a meaningful opportunity to contest the factual basis of that detention before a neutral decision maker. Thus, then, in 2004, in those two cases, Rasul and Hamdi, both citizen and alien detainees were afforded some right to challenge their designation as enemy combatants by the federal habeas corpus process. Shortly after that, in Phase 2, on July 7 of 2004, less than 2 weeks after the Supreme Court had decided the Rasul case, the Deputy Secretary of Defense responded by establishing a procedure to review the status of the detainees at Guantanamo called the Combatant Status Review Tribunal, or the CSRT. And by August 2nd, the first hearings had begun. The CSRT procedure, however, departs dramatically from what we consider normal rules governing courts of law. The detainee does not have access to an attorney. Instead, he is assigned a military officer referred to as a personal representative. The detainee has access only to the unclassified evidence that supports his designation as an enemy combatant. The detainee may attend his own proceedings only when testimony would not, quote, compromise national security. And the detainee can call witnesses on his behalf only if the tribunal determines that they are reasonably available. And witnesses who are members of the U.S. Armed Forces are deemed to be not available if their commanders deem that their presence would affect combat operations. Unsworn statements and hearsay, including evidence obtained by torture, can be admitted as evidence in the CSRT proceedings. Finally, the order establishes a rebuttable presumption in favor of the government's evidence. A preponderance of the evidence standard is used, and a majority vote of 2 of the 3 officers who sit on the tribunal is required to deem a detainee an enemy combatant. Finally, if a CSRT, by some chance, should conclude that the detainee is not an enemy combatant, the government may seek repeated hearings before other CSRT tribunals until it succeeds. Also, in response to Rasul, the Congress in late 2005 passed the Detainee Treatment Act, or the DTA. The DTA amended the federal habeas corpus statute by stripping the federal courts of jurisdiction to hear habeas corpus petitions brought on behalf of detainees at Guantanamo. The DTA also granted the District of Columbia Court of Appeals a limited power of judicial review of the results of CSRT proceedings, but only to determine whether the hearing was conducted in a manner consistent with the standards specified by the Secretary of the Defense. Likewise, the DTA also granted the D.C. Court of Appeal the power to review the final outcome of military commissions conducted under the authority of the November 2001 military order. Then, in late June of 2006, in a case called Hamdan versus Rumsfeld, the Supreme Court addressed a habeas petition by a Guantanamo detainee brought before a military commission for the first time since the passage of the DTA. Salim Hamdan allegedly had served as bin Laden's personal driver and bodyguard. After being captured by an Afghan militia, he was turned over to U.S. military custody in 2001 and detained at Guantanamo. On July 3rd of 2003, the President announced that Hamdan was eligible to be tried before a military commission under the authority of the 2001 military order. 1 year later, in July of 2004, Hamdan was charged by the military commission with conspiracy to attack civilians, and on November 8 of 2004, in response to a petition Hamdan had filed, the district court in the District of Columbia stayed the military commission proceedings on the following grounds. First, that the President's power to grant military commissions extends only to offenses triable by military commissions under the laws of war. Second, the law of war includes the Third Geneva Convention. Third, Hamdan was entitled to the full protection of the Third Geneva Convention until adjudged in compliance with the treaty not to be a prisoner of war. And four, in any case, the military commission convened to try him violated both the Uniform Code of Military Justice, or the UCMJ, and Common Article 3 of the Third Geneva Convention because the commission had the power to convict based on evidence Hamdan would never see. The D.C. Circuit reversed the district court, holding that the Geneva Conventions was not judicially enforceable and that the commission's proceedings did not violate the UCMJ or the regulations implementing the Geneva Convention. The Supreme Court granted review to determine whether the military commission trying Hamdan had authority to do so and whether he could invoke the protections of the Geneva Convention. After first finding that the DTA did not strip the federal courts of jurisdiction to hear habeas petitions filed before the DTA was enacted, the court turned to the merits of Hamdan's challenge to the authority of the military commission. It found no explicit congressional authorization for the 2001 presidential order establishing military commissions, either in the AUMF, the UCMJ, or the DTA. Further, the court held that the military commission created to try Hamdan was unlawful because its procedures did not comply with the Uniform Code of Military Justice. The court also held that the military commission procedures were defective because they violated Common Article 3 of the Geneva Conventions, finding that the Geneva Conventions were part of the law of war, to which military commissions must conform under Article 21 of the UCMJ. It rejected the government's argument that Common Article 3 did not apply to the conflict with al-Qaeda. Thus, finding neither specific congressional authorization for military commissions, nor that the military commissions complied with the UCMJ and the Geneva Conventions, the court reversed and remanded for the habeas petitions to proceed on the merits. Then, in Phase 3, in response to the Hamdan decision, Congress, in October of 2006, just before the midterm election, enacted the Military Commissions Act, or the MCA. The MCA was the first explicit legislative authorization to try unlawful enemy combatants before military tribunals. The MCA also again amended the habeas statute by applying the habeas jurisdiction stripping provision to all individuals who were determined either to be enemy combatants or who were awaiting such determination. The MCA also provides that this new habeas stripping provision should apply in all cases without exception, pending on or after the date of the enactment of the MCA. The first major appellate decision in a Guantanamo detainee case to be considered after Hamdan and after passage of the Military Commissions Act was a case called Boumediene versus Bush. Decided on February 20th of 2007, Boumediene was a consolidated appeal of a number of Guantanamo detainees' petitions for writs of habeas corpus. A divided panel of the District of Columbia Court of Appeal ruled that the MCA had effectively stripped the federal courts of jurisdiction to hear already pending habeas petitions by detainees in that case. The majority reasoned that the statutory language requiring the amended version of the habeas statute to apply to all cases without exception and the legislative intent were both clear. And thus the court interpreted the language of the MCA as overriding the Hamdan case and applying two habeas petitions filed prior to the enactment of the MCA, which of course included all the petitions in this case. The District of Columbia Court of Appeals also held that the MCA removal of habeas jurisdiction did not violate the suspension clause based on its reading of the historic cases. In dissent, Judge Rogers argued that while Congress did intend to revoke the federal court's jurisdiction to hear habeas petitions by detainees from Guantanamo, such a revocation of jurisdiction exceeded Congress's powers. Judge Rogers read the historical cases differently, finding that the writ of habeas corpus, as it existed in 1789 when the Constitution was adopted, would have extended to aliens held abroad, and further argued that the majority ignored important dicta in the Rasu case that indicated that the historical writ would have extended to Guantanamo Bay. After first denying review, in late June of this year, the Supreme Court reversed itself and agreed to hear the Boumediene case. That, in brief, is a history of the twists and turns of the administration's war on terror detainee treatment policy and the legislative and judicial responses to the administration's initiative. The legal status of enemy combatants in military custody, both at Guantanamo and in the U.S., continues to change rapidly, in part because of amendments to the habeas statute and changes in the administration's classification procedures. Habeas petitions of detainees often become moot before the courts can rule on constitutional challenges. These statutory and regulatory changes, coupled with the Supreme Court's reluctance to rule on constitutional questions, have left the Guantanamo detainees in what's best referred to as a state of legal limbo. So it has now been nearly 6 years since most of the Guantanamo Bay detainees have been captured and turned over to U.S. custody. It has been nearly 3 years since the Supreme Court ruled in Rasul that detainees at Guantanamo have the right to petition for habeas corpus. Yet, hundreds of detainees continue to be imprisoned without a hearing to determine their status and without recourse to the courts. It is clear now that the administration's choice of Guantanamo Bay as the site of its primary detainee prison was based on a misperception that the writ of habeas corpus will not apply there because Cuba retained residual sovereignty over that enclave. Rasul proved the faultiness of that legal logic. In an effort to circumvent Rasul, the administration jerry-built the CSRT system, a system seemingly designed to deny the detainee of every procedural right our legal system, including our military legal system, has developed to ensure that a hearing is fair, that the accused receives due process. The detainee does not have the right to see the evidence against him. He has no right to an attorney and no right to present evidence in his own defense. The detainee does not even have the right to attend his own hearing. And if the government by chance loses, if the CSRT finds that the detainee is not an enemy combatant, the government can simply convene another CSRT tribunal to try again and again until it does succeed. The administration also convinced the compliant Congress in the MTA, enacted in 2006, just before the midterm election, to provide that detainee enemy combatants could not bring habeas corpus petitions in any U.S. courts. It is argued that this provision does not violate the suspension clause in spite of the language in the Rasul case to the contrary, and in spite of the fact that the limited judicial review of these proceedings is not an adequate substitute because it cannot result in the detainee's release from custody, the very purpose of the writ of habeas corpus. We can expect a major decision from the Supreme Court in the Boumediene case in the term that starts in 2 weeks. First among the questions presented is whether the MCA's jurisdiction stripping provision is a valid exercise of congressional power under the suspension clause. Subsidiarily, the petitions also present the question of the source of executive authority to detain the petitioners at all. In the lower courts, the government relied on the AUMF, but the AUMF did not grant the president a roving commission to detain and imprison suspected terrorists anywhere in the world. It specifically limited the president's powers to, quote, to use all necessary and appropriate force against those persons he determines committed or aided the terrorist attacks that occurred on September 11 of 2001. Most of the Guantanamo detainees were not captured by U.S. military forces, but the great majority of them were turned over to the U.S. by Northern Alliance and Pakistani forces in exchange for substantial monetary rewards. In the case of the Boumediene petitioners, they are Algerians who had immigrated to Bosnia in the 1990s and who were turned over to the U.S. custody immediately upon their release from Bosnian custody. But whatever the court says in that case, the writ of habeas corpus cannot by itself obviously serve as the cornerstone of our detainee treatment policy. Congress must take the laboring oar and provide a statutory framework that comports with the rule of law and with our Constitution and treaty obligations. We must return to first principles, that under our Constitution, our federal government is a government of limited enumerated powers. Nowhere in the Constitution or in any law enacted by Congress is the President granted the power or right to capture suspected terrorists anywhere in the world and to detain them in custody for an indefinite period of time without being charged with a crime, without access to counsel, and without any right to a hearing before a neutral decision maker. Something is wrong with that picture. But that is exactly what the administration claims it has the power and the right to do. Many have likened our detainee treatment policy to a kangaroo court. Is it any wonder that much of the world now sees the U.S. as a lawless country without any respect for the rule of law? The American Bar Association recently conducted a poll of 50 lawyers who were involved in the defense of terrorism cases. 58% of them disagreed with the statement that, quote, the terrorism cases brought in federal courts have made the U.S. safer. 80% disagreed with the statement that, quote, terrorism laws passed by Congress have made the U.S. safer. 84% of those lawyers thought that of the three branches of government, the executive branch, quote, has acquitted itself the worst on terrorism legal issues. And something I think an academic audience will appreciate, in answer to the question, what grade would you give the entire U.S. justice system, including the executive, legislative, and judicial branches, in the legal war on terror? 54% gave the U.S. system a grade of D or F. The survey responses were limited to defense attorney because, for whatever reason, the U.S. Department of Justice refused to permit government lawyers to participate in the ABA survey. It should be obvious that the ship of state is badly in need of a course correction, which Congress must provide. First, Congress must repeal the purported suspension of the writ of habeas corpus. Second, either by reference to established law, such as the UCMJ, or in a standalone law, Congress must enact new detainee hearing and appeal procedures that comply with notions of minimal due process and grant a timely hearing to all detainees, and further that if any detainees are to be subject to criminal prosecution, that detainees to be charged with crime be charged promptly and tried according to established and accepted procedures, either under the UCMJ or in our federal courts. I close by noting that 65 years ago, I, together with 120,000 other Japanese Americans, was subjected to indefinite detention under Executive Order 9066, which the executive branch then claimed was not subject to judicial review. I was in turn held in detention for 3 years and 3 months. It took 46 years for the U.S. government to own up to the wrongdoings in the World War II Japanese-American internment cases. In the Civil Liberties Act of 1988, it offered an official apology by the President for the wrongs the government had committed. The Guantanamo detainees have now been detained, imprisoned under inhumane conditions for 6 years in violation of our Constitution and our treaty obligations and in flagrant disregard of the rule of law. Let us not wait another 40 years before we right these wrongs. Let us remember what we are fighting for and not lose our soul in the process of waging the war on terror. Let us return to the rule of law in our treatment of war on terror detainees. Thank you very much.
I want to thank you very much for your talk. Very well, much appreciated, and probably should have been attended by more people than are here, which indicates what's happened at the University of California in the past few years. My question is this. Guantanamo has gotten a lot of attention in the newspapers and various places. The detainees in this country have gotten much less attention. How do you explain the silence of law professors all over the country, with very few exceptions?
Well, that's a terrific question, but I'm just a judge. I'm not a psychiatrist. I'm not a psychologist or a social psychologist. But I agree with you. We haven't heard too much from the academic arena, except I do note not too long ago, maybe Professor Schreiber remembers this, but there was I think a joint letter signed by a number of leading law school deans on this subject, which I thought was, regardless of which side you're on, I think they do have an obligation to speak out, and I was glad to hear them speak out.
Judge Tashima, could you tell us where you attended law school in your early career?
I'm sorry, I missed it. Did you get?
Oh, your early career and law school experience? Yes.
Where did I go to law school? I went to, well, let me say I graduated from the UC system because I'm a graduate of UCLA. But then I went back east to law school, to Harvard Law School. In those days, I could say some things about it, but I won't. But I went to Harvard, yes.
So the judge mentioned that to kind of solve our problem with rule of law, the Congress should enact laws which provide procedures and so forth. And he also mentioned that the Supreme Court has been reluctant to rule on constitutional issues, especially those pertaining to habeas corpus. And so I'm wondering, what do you think the Supreme Court can or should do? Because if your solution consists of asking Congress to do something, well, there's a certain amount of political inertia. I don't think, and many congressmen and women want to vote for something which somehow helps the terrorist quote, right? But the Supreme Court has the benefit of being able to decide without, being blown by the winds of political what have you. So, yeah.
I understand the thrust of your remarks, and I think they're well taken. That many people, at least until very recently, have been reluctant to speak out on various practices that are associated with the war on terror, simply because it hasn't been politically expedient. But I think that atmosphere is changing somewhat. I'm hopeful it will change some more. But in the end, the courts and the Supreme Court are really institutions of last resort. It's really not up to the Supreme Court to make, to declare what our detainee policies are with respect to war on terror detainees. The role of the Supreme Court and of the courts is to tell the Congress and the administration when they've crossed the line to the point where their acts have become constitutional, such as the issue before the Supreme Court in the Boumediene case. Is the Military Commissions Act, which says no war on terror detainee can bring a petition for habeas corpus, is that a suspension of the writ of habeas corpus? When the Constitution says the writ of habeas corpus, I think Professor Schreiber knows it better than I do, but Congress shall not suspend the writ of habeas corpus except in time of rebellion or in case of invasion. And we certainly have no rebellion and no invasion. And the habeas corpus has been suspended only, 5 or 6 times in the entire history of our country. And so is this a proper exercise of that? Well, the Supreme Court will rule on that, but that really shouldn't be the end of the answer, and that's not, the way to formulate public policy. At some point, I think the political branches have to get involved. Congress has to say to the administration, well, look, you've gone too far in these policies, and it's time to, square them, with what this country is about. And that really, I think, is a political decision in the end. There's somebody back there.
Thank you, Judge. I represent the newly formed No Torture Project of the Bay Area, focused on the Bay Area representatives of the Bush torture program. Martin Luther King said that if you're not part of the solution, you're part of the problem, and you are part of the solution, Judge. Thank you. We so badly need more people like you. John Hughes, that's John Yu here at UC Berkeley, is known as Bush's architect of torture. He's tenured here at UC Berkeley. He is one of the most responsible in the Bush regime for the legal basis and making legitimate of the enemy combatant status. Yes? Okay. Psychologists define torture not only as physical violence, but as the destruction of hope. Indefinite detention and no hope of legal recourse destroys hope and is torture. If you were a student here at UC Berkeley today, what would you be doing to see that John Yu is prosecuted for crimes against humanity? How do we give hope to that justice?
Well, my first observation, I don't think it's a place of anybody at the university to prosecute a faculty member for any crime. I don't care what it is. Professor Yu, whom I've never met, by the way, and I obviously have different positions on how the war on terror should be conducted. I don't know Professor Yu, but I know the man he worked for, who's now a colleague of mine, Judge Bybee, who was at that time when Professor Yu was in the administration, the Assistant Attorney General in charge of the Office of Legal Policy. I don't doubt that these people held their positions in good faith. I think you're focusing particularly on the so-called torture memos, with which I disagree, but I think at the same time, when what bothers me more, for instance, is when the Supreme Court comes down with a case like Rasul that says, yes, these people at Guantanamo are entitled to have their petitions for writs of habeas corpus heard. Then the administration still, what is this, 4 years later now, doing everything it can to prevent these people from having their day in court. In other words, not making it what I consider a good faith effort to comply with the dictates of the Supreme Court. I think that bothers me more than taking some position on the, on torture, which, once it comes to light, I think, the good sense of the American people, I think, caused that administration to pull back on that policy, which I think is the right position. But that's as far as I can comment on Professor Yu. I think he's I don't think any, it's not to me to pull academic freedom, but I don't think any professor should be, fired because of a position they take on something like that. I think, it's fine to debate them in public about the wrongness of their position, but it's not for me to say certainly, there's some ground for revoking tenure. But that's to me that's a university matter, which I don't pretend to know anything about.
Thank you, Judge. I certainly agree with your proposals for new legislation. I'm just concerned that the pattern of abuse is so much larger than the law itself. Essentially, it seems to me sometimes that Congress and the judicial branch need their own military forces to be able to counteract this. That's certainly not practical, nor would I even want it. Just your comments as to whether another law will even slow anything down. Thank you.
Well, it takes time, obviously, for any law to sink in and to take effect. To give you a good example, something all of us know, remember, even the younger people here, it took I think Brown versus Board of Education, probably a generation, to have any substantial effect on the on educational opportunities of African Americans and other minorities. So I'm not saying passing a law is a panacea, but certainly it's something that would help in terms of forcing the administration to confront, I think, what I considered, erroneous premises upon which its detainee treatment is based, and hopefully to help bring that in line. In some sense, I share with you some of the skepticism that is this really going to change what's happening in Guantanamo and other places in the world. But again, you see, I see that the reason I think it's important for the Congress to act, because Congress does, after all, represent you and me, the American people. And it brings to bear, I think, the conscience of the American people, and I think that, more than the technical words in the statute, is what I hope any administration, this one or any new one, will pay attention to.
You have very eloquently described the missteps of the administration and the legislative branch and moving against the rule of law. But if that had not happened, if we had taken the best possible view of the rule of law and the country had been presented with several hundred combatants from Afghanistan, would the rule of law, as you envision it, been sufficient to deal with that problem if the government had not taken the missteps you so wonderfully described?
If I understand that, I'm not sure I understand your question, but let me try to answer it this way. I think the concept of the rule of law certainly can be brought into focus in dealing with the detainee treatment issue. After all, these detainees now have been in custody for many, many years. I think at one time it was thought, and maybe the administration even said, well, the reason we're keeping them because we want to, milk them of all the intelligence we can get. Well, it's been 6 years, and you can only get so much intelligence out of any person, no matter how hard you try. You can't, in what kind of hearings and trials these detainees to get. At one time, there was consideration was being given to actually be giving these detainees some kind of hearing right on the battlefield as soon as they were, within a short time after they were captured. But for some reason, that was done away with. You can see in that kind of setting where you might take shortcuts which you wouldn't take in the comfort of home. But after you've held somebody in prison awaiting trial for 6 years, I don't think you can have the excuse that, well, it's going to interfere with our combat operations, or, this is a military situation, so we can't be concerned with the niceties that you have in civilian life. And we're only talking about 300 or 400 people, maybe 500 people. And the fact is, in the, say the federal court system, for instance, the federal court system handles, I think, a couple 100,000 cases a year. So it's just a very, I don't think it would be cost more than a blip in terms of, the volume that it would take. And being so far now removed from the conditions of the battlefield, I don't think these conditions about military necessity have very much play in the situation any longer, if they ever did. Okay.
I want to thank Judge Tashima for her eloquent and challenging address.
Thank you.